Morning, Your Honor.
Guys, next Steve. All right, good morning. We have a reporter? Nope. All right, this is the second motion for continuance, which I read. And any additional arguments this time?
Your Honor, a plaintiff is a prisoner. We received a order to take his deposition in January. There was some bureaucratic finagling, for lack of a better word. He's now in Carabel. We're seeking to continue on April 1st.
When would you think you'd be ready to go to trial?
I mean, I'd like to roll it over to September if that works for plaintiff.
Yeah, we spoke about this because we were trying to figure out the logistical issues. I mean,
We have to transport and all that stuff, so you think September would be enough time?
I think that would probably be sufficient.
Not a problem, I'm happy to do it, I'll go ahead and do it, and as you guys know, I'll special set it for you guys. So that'll be easy, then we can give them advance notice, we can work on all the arrangements for the transport.
Okay.
Okay, so motion's granted.
All right, thank you, Your Honor.
Have a great day.
You too.
All right. State Farm versus Gray Red. Okay, good morning. Good morning. Are both sides here?
The other side is a default. I guess I thought against
Okay,
it.
so the petition to report the umpire, which is perfectly fine, and a motion for entry upon land and inspection. And I'm happy to grant both. Do you have a proposed umpire for me?
I have orders on both.
I have it great. All right, thank you so much. Have a great
Thank
day.
you. Thanks.
All right, okay, no problem.
Thank you, Your Honor.
Thank you. And that trial continues, we said in September. I just got it. 8:30, nobody's here. Is anybody down to 8:30? Anybody show off Townsend versus Johnson? No show? Okay, no problem. All right, let me do a couple case management conferences as well. Freedom Mortgage versus Strawberry Lakes. Anyone here on that one? Freedom Mortgage, Strawberry Lakes. No show? Graham versus Oshipinki?
Oh, yes, Your Honor.
Yes. All right, good morning, counsel. And what's the status of this case?
Your Honor, we actually served the plaintiff, the defendants, and, well, January 8th, one of the defendants was served, and we filed notice of service as well as a motion for clerk's default yesterday with the courthouse.
Great.
They said that they served the individual plaintiff, individual defendant, but I don't believe it was proper, so we're going to have to file a motion for extension of time and probably do a notice.
That's fine. I'm happy to grant your extension time for service. How much additional time do you need for service?
We're going to have probably 60 days because we're going to have to do it by
I'll just put that in order now, so that way you don't even need me to follow the motion. I'll give you the 60 additional days for service.
Thank you, Your Honor.
Okay, just put that in order. Thank you so much. Clinton versus Geico. Is everybody here? Let's see where you guys are on the case.
The short contract, we're missing the Geico order.
Not a problem. All right. Do we have any teams ready for UMC? Anybody, any teams ready? Not yet? Okay. All right, let me do Christiana Trust versus Unknown Heirs, foreclosure case.
Morning, Your Honor. This is the motion to substitute party plaintiff.
Yeah, everything looks good. I'm happy to grant it and send you over.
Perfect. Thank you so much. You as well.
All right, Strand versus Alban. Strand versus Alban. So this is Judge Kaiser. Are you guys in the wrong courtroom? Says Judge Kaiser. Hopefully you're not in the wrong courtroom. You're in the wrong courtroom. It says Kaiser. Lakeview Loan Servicing versus McLaughlin.
Yes,
All
Judge.
right, good morning.
Good morning. The other side is not here just yet, so thank you.
U.S. Bank Trust versus, is it Gainem? Got it.
Good morning, Your Honor.
One second, fellas.
This one was special set, Your Honor, for
Yeah.
15 minutes.
We'll just wait for a couple more, so let's get it set up.
My opposing counsel, Your Honor, is in
No, I'm right here.
Oh, you are? I'm sorry. I'm not even.
No problem.
Okay, I'm ready, and if y'all would identify yourselves, please.
All right, let's go ahead and go on the record. We're in U.S. Bank Trust versus Ganem. Could counsel please state their appearances for the record?
Justin Kelly for the plaintiff. Good morning.
Leave some on it for the defendant.
All right, good morning. This is the plaintiff's MSJ, and I read everything, and you may proceed when you're ready, counsel.
Your Honor, I don't know if the court wants to address it. Counsel cross-noticed a motion to continue this, so maybe
You
we
want to argue
should.
that first? Motion?
Yes, Your Honor. I mean, it's all tied into the discovery.
What are you still missing from the discovery?
Just about everything, Your Honor. They've
Did you file your
objected
affidavit under the rule?
that there's missing discovery.
Yeah.
No, I didn't, but I filed it in part of my motion.
You have to file that as part of the affidavit under something different.
Okay, well, but
we filed, we noticed this for hearing several times.
I know, but you gotta follow the rules of civil procedure. The rules of civil procedure say when you have an MSJ and you're seeking a continuance based on outstanding discovery, you gotta follow the rules of civil procedure.
I understand that.
Okay, so motion for continuance is denied. So,
Okay.
All right, Your Honor, if we're proceeding with the summary judgment, I think we filed an extensive affidavit that attaches, they've raised the typical foreclosure affirmative defenses, standing and lack of the demand letter condition precedent that I'm sure Your Honor's familiar
I
with.
know.
We filed a very extensive affidavit showing not only the existence of this letter, but we've got also attached documents that show it was sent. While there is a document on the docket that says it's an affidavit in opposition,
Yes.
if you take a look at it, it's not signed by anybody.
yeah, let me just ask you, I saw that when I was preparing last
There is a
night.
signed affidavit.
Who signed the affidavit? What's the date? So I can pull it
Mr.
up.
Michael Gunham signed it.
Okay, let me
It was
pull that.
submitted, I'm pretty sure, to the court.
What was the date of the affidavit?
I'll find it for you.
I signed it, John.
Okay. I thought I just need to see that.
I think it was, well, if I could have a second, Your Honor, here.
Take your time.
This is the affidavit, Your Honor, and I believe it was submitted, and this is proof that it was submitted on the
Okay,
18th.
can you show
Can I-
counsel, please? Michelle says the password is incorrect. I tried it all.
It's on the, it shows on the
I
docket.
see what counsel's got in his hand, Your Honor, but this, if I may approach, is what's on the docket and what we received. That's got the clerk's stamp on it.
Where's the signed one?
It's right here, Your Honor.
Where's the one that's signed in the court?
Well, it
With
should
the,
be,
with the filing?
well, it shows proof of filing right here.
No, with the clerk, with the portal filing.
I don't have the.
Then I
this
don't
is-
believe it. It's
this
gotta be
is-
in the portal.
This is the only thing
Then
that,
it has to have a portal. That's why we have e-filing in Florida. Where is the portal filing that
it
was
was,
actually filed?
well, it was filed in the portal.
Where is it? Show me a copy with the portal filing.
This is the only thing I've got. It was filed on 1/18/2019, and it shows, this is the portal filing, Your Honor.
No, if e-portal filing always has a number on top. You know that, counsel.
Yes, I know, but I only have a copy. I don't have the one that has the,
Tell me the date. Show me the document. please.
1/18, Your Honor.
I'm going to try to pull it up. I'm having computer problems, so I can't get it in my...
That's okay.
Mark, can you get Michelle, please?
Yes.
And this one's not even filled out. This one doesn't even have a date or anything on it. It's completely blank.
I don't understand that, Judge, because this is the one that we submitted. And I don't
I think your
understand.
office made a mistake. This one doesn't, it's signed. It's not even verified. It's not even checked off. This is...
Well, yeah, I know, but I have it right here, Your Honor.
Michelle, can you verify that counsel's accurate? He claims he filed a sworn affidavit on January 18th. I can't get access to my computer.
I can give you a copy of it.
No, sir, I don't believe it unless I see the court file, because your copy does not have a copy with the clerk's docket on it. So
Okay.
the only one with a copy of the clerk's docket on it doesn't have a signature. So, yeah, can you please pull it up so I can see it, Michelle?
Yeah.
I saw it, yes, yeah, I see it. Okay, yes. Let me take a look at our computer, hold on. Nope, no, sir. The one in the court file is blank.
I don't understand what happened,
You're
Your
absolutely
Honor.
mistaken.
Okay.
This is the one in the court file, this is not acceptable, it's completely blank.
That being the case, Your Honor, there's no summary judgment affidavit in opposition. My affidavits are
Please, sir, I'm so
thorough.
sorry.
I know it, I can't believe this, this is never, you know, Your Honor.
It's on the computer.
No, I believe you. Your Honor knows that I've been doing this for a long time,
Maybe
and,
your office made a mistake, I'm so sorry.
yeah, no, it's,
It's completely blank, that's what the court file shows.
I don't understand what happened.
Well, here's what I'll say, I'll go to Becky Summer Judgment, see if you can go to mediation, see if you can save the house and move over.
Well, the
Okay?
judge,
Your Honor, may I say something?
Yeah, you're welcome to, you have counsel, but you're welcome
I
to.
know, but I would like to say something.
Sure.
I pay counsel to defend me. I went down to his office and I signed the affidavit.
It's okay.
but it's a technicality.
It's not filed, I have to
I know,
follow
but I
the
mean,
rules.
don't punish me because...
I know, sir, I have to follow the rules. If you want to try to save your house, would you like to go to mediation?
Yes, I will.
Okay, let's do
Okay.
oral mediation, post judgment.
Judge, first of all, I don't think their affidavit has to prove up their case, and under Finnegan,
What's missing from their affidavit?
well, they haven't authenticated quite a few things, such as service of the default letter, I believe, hasn't been authenticated.
That doesn't need to be proven. That's not what happened.
There's the Servideo case, which Your Honor is quite well aware of, I'm sure, that says that the original note and mortgage has to be filed 20 days prior to the hearing. And that hasn't been done. They filed copies, but they haven't filed the original.
Your Honor, that's just not accurate. No, that's not accurate. I've got the originals right here. It is there's no case out there. As long as there's a copy on record,
Yeah,
that
that's not-
council has notice of
That's not
the
what
documents.
it is.
Under Ortiz, if our note and mortgage attached to our complaint are copies, they look similar or identical to the ones I presented as the originals, there's a presumption of standing, there's no affidavits in opposition. Our supplemental affidavit is very clear that we have attached both a copy of the demand letter and our transaction screen showing it was sent. There's, again, no evidence in opposition, no summary
I'm going to
judgment.
grant the summary judgment. You can go to mediation if you'd like to. We want you to try to save your house. Would you like to go to mediation within 60 days?
Yes, another thing I would like to
Sure.
bring to the court, Your Honor. They bought the loan from a Citibank,
Okay.
which is I have paid all my payment up to date, but they added to the principal instead of the payment.
Okay.
That's why they said I'm late, because Caliber Bank bought it from Citibank.
Okay.
So there is like also a lot of technicality. This has to
All
be
right.
updated.
Summary judgment is granted. You have 60 days to try to do a little modification.
All right, I've got a proposed judgment here. I'll fill out I'll put
90
90 days sale
90 days
date.
sale date.
Can we do 120 or?
Sure, 120 days sale date.
And I'll fill out a separate order for mediation in 60 days.
And let's see if we can get it mediated, okay? We want you to try to save your house if we can. All right, thank you guys. Have a great day, Laura.
Thank you.
Okay.
Here's
Just say everything, Michelle. Thank you so much.
The originals are in there.
Wonderful, thank you so much. Universal Property versus Costa. Anyone here on Universal Property versus Costa? Both sides here, come on up. All right, good morning.
Do you want to fill out orders denying the motion for summary, the continuance?
You can send
I can put that in the
everything-
mediation order.
You can put that in mediation, that's fine.
Yeah,
All
okay.
right, thank you so much. Universal Property versus Costa, and this is the motion withdrawn, motion stay. Is there any opposition?
Just to the requested stay of time.
How much time are you requesting?
Judge, although the motion asked for 30 days, my client has asked for 60 days.
Okay, all right, that seems like a long time.
It does,
So-
my client has given me a phone number. He would like to, if Judge, if the
I'm
clerk would
happy
like
to
to do
call
it.
him, but why does it need 60 days to report?
They're apparently having difficulty. I'm not sure exactly what it is. I'm not privy to what's going
Okay,
on.
all right, he's happy to give me a call. What's going on?
954-309-4039.
I'm sorry, 309?
It's Juan Fuentes.
Okay, all right, let me give him a call.
Thank you, Judge. That sounds like a voicemail, Judge. If I can,
Let me just leave a message so you can try to call him.
At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options.
Oh, good morning, sir. This is Judge Sasser. I'm calling you in Universal Property versus Costa. Your attorney had requested that I contact you this morning regarding a motion to withdraw and a motion to stay, and we tried to do so unsuccessfully. Have a great day. All right, I'm happy to grant the motion to withdraw, and I'm happy to stay it for 30 days.
Okay, Judge, I have an order
Sure,
of my
let's see an
name.
order. Thank you so much. Have a great day, guys.
Thank you very much.
All right, US Bank Collins. US Bank Collins?
Or Rob is over in another
No problem. All All right, US Bank, okay, let's do Lakeview Loan versus McLaughlin.
I'm on that one.
Your team, Lakeview McLaughlin, no? Okay. Clinton versus Geico, is everybody ready on Geico? All righty, we have corporate? We do, all right. Good morning, everyone. Nice to see everyone. We are here in Clinton versus Geico, and I know you guys have been working really, really hard, which is great news. So I want to see where you guys were with the case.
We are heading towards Monday.
Okay, all right. So, well, how many defendants are left, and what's the status?
We are down to 2 defendants, Baumstein and Geico.
Okay, I'm sorry. Okay, so
The 2 that were dropped were, let's see, Madelon and Davidoff are out.
They're out. Got it. Okay, if you have orders on those, I'll take care of those.
I don't think, I know this just happened last week. I know I saw a stip of dismissal circulating. I don't know if it's been submitted yet. I know
We
it
haven't, I
crossed
don't
my
think we've
desk.
seen it yet. So when you get a chance, just send me the orders.
We will.
All right. So now that'll change the number of jurors. And how many peremptories do we have?
It'll be 6 for plaintiff, 3 for each defendant.
Correct.
All right.
And the recently dismissed defendants are now fat rate defendants.
Got it. Okay, no problem. then. So we obviously don't need as many jurors then, and we don't need it's not as big a deal. We'll just treat it as a regular case. We don't need to do pre-qualification, any of that stuff. So we'll just do it as a regular case then at this point in time. How many days for the trial?
I think we're down to 5 to 6.
That sounds about right, Judge. I don't know. I've never tried it in front of Your Honor. I don't know.
Really fast and really efficient.
I'm
So,
shocked.
yeah. So probably 5 would be my guess.
Let's
So,
hope.
okay, so we should be able to do it in a week. You guys keep us posted on everything too?
We will.
Okay.
Yeah, we're still talking, but.
Yeah, it sounds like
never know.
things might still work out, but okay,
We'll see.
from your lips to, settle with God's ears.
Until then, the foot's on the gas.
Yeah, just keep the foot on the gas, keep working at it. So what I'll do is rather than the large panel then, since we're only gonna have 6 and 6, you think maybe 50 jurors is enough?
Should be.
Okay, all right, 50 jurors it is?
50.
I don't think we need that.
Would probably maybe 40, probably 40, because I'm usually pretty good on the,
Well, the only
questions.
concern is you have Geico involved, which could generate.
We usually get a little
Yeah.
bit more, but let me do 4. I think we'll be okay with 40.
40 should be
for
fine.
enough. And that way we can squeeze it in my courtroom. I think 40 jurors should be enough then. All right, we'll see you guys on Monday. Keep trying to get it resolved.
So Friday morning's off.
Friday morning, yeah, that'll make your life much easier. Because now we don't have to do everything ahead of time. It's much smaller, and we can get the case tried in 5 days.
Very good.
All right, thank you guys. Have a great day, everyone.
You do.
Oh, and Your Honor, just one thing for, at some point, because we've got 3 experts on video,
Yeah.
we're going to need to have an opportunity to deal with objections.
Not a problem. I'm happy to
Earlier
do
the
it this
better.
week if you guys want to even do it. If you guys want to come in on the time you had set aside on Friday, I can do it then.
I don't know if the transcripts are going to be ready, to be honest with you.
Yeah, because we shot one just on
Yesterday.
Monday.
Okay.
One's going to be after,
And one is
One's
Friday
Friday.
at 12:30.
Oh, so then we'll have to wait then. I'll work time in, that's not a problem. And I will need jury instructions verdict form and when you guys get a chance
We
then.
circulated a verdict form last
Okay.
night. We're working on jury instructions, and we have to redo the stip now that we've changed the parties.
Wonderful. The other thing we do is we do juror questionnaires to make your life much easier. And Michelle can go ahead and email them to you guys. It makes your diary much easier, much more efficient, and you guys will really enjoy it. So Michelle will send you copies if you guys need them as well.
That'd be great.
Okay, whatever you guys need, please don't hesitate to ask.
Thank you.
You guys have a great day. All right, let me go ahead and please do we have a team now on Lakeview McLaughlin?
Not yet, Judge,
Okay.
I'm sorry.
Okay, so we just did this one. Okay, Law versus Survey Partners. Council ready? We have a team? Not yet?
Looks like we're still
Okay.
missing it.
All right, let me do Feinberg versus DeSisto.
The court reporter, Your Honor.
Okay.
Morning, Judge.
Good morning, guys. All right, nice to see you both. We have a court reporter. If all counsel could please state their appearances for the record.
Did Urbanic with plaintiff?
Greg Weiser for the defendant.
All right, you guys have your new trial date, and you guys did you get your juror questionnaires? Did you guys work at that issue yet?
No.
Okay, we
I
need
think
to
we
work on
decided
that.
to use your default.
Is that what you're gonna use?
Yeah.
Okay, that's fine then. So you guys have the juror questionnaire, which again will make your life much easier during the court hour. Are you guys still 5 days for the trial? I just need to confirm.
Yeah, I think so.
Okay, you have that entire week, April 25th, the 5 days, special Saturday.
March 25th.
Oh, March, I'm sorry, what did I say, April? March 25th. You're exactly right. Yes, I'm jumping ahead.
That week was not good, but they allowed to put some witnesses out of turn, so we're going to have those issues.
Excellent. And we can always take witnesses out of turn, that's not a problem. I know that there were some depot designations, are you guys
Yes,
ready?
and that's what we're here today
Yeah.
about, their objections. And Your Honor, did you get the?
I did, thank you so much, it was
Okay.
very helpful.
And do you want us to argue them individually, or have you already made up your mind on some of them? And
I'm happy to go ahead and, I went through everything. Do you need more time? I'm happy to take everybody else and take you guys at the end.
I think that would be good. That way we
Is that
won't
okay?
equal up.
I
Yeah.
have a deposition in Coral Springs at 10:30.
Okay, or I can even do it later on if you guys want to. We have plenty of time if you guys want to do it maybe 10:30 at Coral Springs. So that'll, well, you know, I'll probably be done by about 9:15. Not a problem then. So why don't you guys have a seat? Let me finish with everybody else, then we'll call you guys out. All right, thank you so much. Factory Health Management versus Blue Cross Blue Shield. Council Brady, Factory Health?
Yes, good morning,
All
Your
right, good morning, guys.
Judge, I'm here on that one.
Okay.
Honor. Good morning, Your Honor. Jose Reguero on behalf of defendant Walmart Inc.
Good morning.
Good morning, Your Honor. Culver Smith on behalf of plaintiffs and plaintiffs' counsel.
Good morning. Yes.
We do have several counsel that are out of town that were calling in. If I can approach, I have a call.
I just need a phone number, yeah.
Thank you.
Perfect, thank you so much.
Yeah, it's a dial-in number with a code. Thank
Give
you.
her a call.
Welcome to Reservationless Plus Conferencing. Enter your conference code, followed by the pound or... Thank you. After the tone, state your name, followed by the pound or hash sign.
Big Sasser?
Thank you. You will now be placed into conference. To mute your line, press *6. To unmute, press #6.
Counsel on the telephone, are you ready for the hearing?
Yes, Your Honor, this is John Lorenzo.
Wonderful, we have a court protocol. If all counsel could please state their appearances for the record.
This is John Lorenzo, and I'm appearing on behalf of Walmart Inc.
Your Honor, good morning. This is Tim Connor. I'm appearing on behalf of defendants Blue Cross Blue Shield Florida, Blue Cross Blue Shield Louisiana, Highmark, Jamie Hansen, and Candace Ford for independent.
Wonderful. And counsel?
Yes, Your Honor. Jose Reguero on behalf of...
I didn't get that at all, Judge.
Counsel, the court order, Mr. Name, can you please repeat it?
Fred?
Good morning, Your Honor. This is Patrick Gravel on behalf of defendants Care First of Maryland, Inc. and Group Hospitalization and Medical Services, Inc.
Wonderful. Anybody else on the telephone?
Yes, good morning, Your Honor. Jason Snyder, representing plaintiff for health management, NCO Pharmacy, and FHM Group.
Morning, Your Honor.
Jude.
I'm sorry.
Morning, Your Honor. This is Jude Cooper. I represent Care First of Maryland Incorporated and Group Hospital and Medical Services Incorporated.
Good morning, Your Honor. George Casal on behalf of Blue Cross and Blue Shield Association and Calvin State.
Wonderful. Good morning, everyone. And counsel in the courtroom, please?
Yes, Your Honor. Jose Reguero on behalf of Walmart Inc.
Culver Smith, may it please the court, Culver Smith, on behalf of the plaintiffs' counsel, and 3 individuals who've been recently named in this motion.
All right, good morning, everyone. This is the request for the case management conference, and I had a chance to go back and review the court file, and counsel, you may proceed when you're ready.
Thank you, Your Honor. As Your Honor is aware, on February 20th of 2018, the court entered final summary judgment in this case in favor of the defendants. The defendants, including Walmart Inc., have filed several motions for sanctions, attorney's fees, etc., under 57105, as well as other grounds that are listed in the motions that have been filed. And I just recently appeared in the case replacing Mr. Berman, who retired. But I haven't had communications with counsel. My understanding is that the case management order that was attached to the motion has been essentially agreed to by all sides.
Excellent.
With the exception, the only understanding I have that's an issue is the defendants would like the ability to take depositions of certain individuals who will oppose a motion. I understand that's being opposed, so I think that's what these, and in addition to that issue, a matter of scheduling the hearing, and I think the parties are shooting towards May.
Okay. All right, so let me just talk about the depositions issues. What's the objection to the depositions?
It's basically because of the amount of time where we were. You remember in July, we were ready to go.
I know.
And they weren't. And you graciously and appropriately, leave my affirmation additional time to decide, I thought, to decide who were they going to call at the hearing and what exhibits they were going to use. And then it's mushroomed or exploded into this now discovery search mission.
Okay.
So we don't have an objection to the entry of a case management order or this one, except that it sets a deadline for depositions. And I suppose setting a deadline for depositions is not a problem for us, but I just want to alert the court that we're probably going to be objecting to a lot of them for those reasons.
Okay.
It seems to me we ought to be setting a hearing and moving forward with witness and exhibit exchanges and nothing else.
And I'm happy to do that. First of all, would May be an appropriate time? Do you guys think you'd be ready for May?
It depends on the date, but yes.
No, and I'll special set it for you guys. Whatever date, I can work around my trial schedule. If you have some proposed dates, just email Michelle. I know there's a lot of counsel involved. If you guys want to circulate a proposed 2 or 3 proposed dates that work for everyone, we'll be happy to work around your schedules, if that works for everyone. So what I'll do is I'll go ahead and set the, and how many hours do you think the hearing will be? How long do you think?
Well, I'd set us
Maybe a full day?
full day.
Full day, okay, that's fine. So we'll do a full day in May. Just pick some dates for me, and then we'll be happy to special set it or whatever dates work for you guys in May.
All right.
And then backing off from that, if you want to, with the scheduling order, we can have cutoffs in there in terms of discovery in advance of that. I'm happy to do
Right,
that.
that's the way the orders are crafted.
Okay.
And I did want to alert the court to the addition of these 3 individuals who are more or less principals of the plaintiffs. And that, it seems to me that you do not have jurisdiction over them to impose sanctions on them, but and I don't know if that'll affect the length of the
It
hearing.
may or may not. I assume if they're added to the sanctions, and there may be a motion to dismiss or strike or something that filed. So I'll have to take that up, tee that up before then. So I'm happy to give you additional hearings in advance. If they've already added these additional 3 defendants, then you can certainly file, Mr. Smith, a motion to strike or motion to dismiss those individuals if the court doesn't have personal jurisdiction over them, and we'll be happy to take care of them. So I'm going to grant your motion for entry of case management. I'm going to special set it on a date that works for all counsel in May. Please send me some proposed dates, any date that you guys want to. I'm happy to set you guys, and then we will work backwards on the deadlines, and you can do the depositions if you need to, but they have to be coordinated with the other side. Okay? All right, thank you
very
guys.
much.
Have a great day, everyone. Nice seeing you.
Thank you, Ron.
Thank you, guys. Have a great day on telephone counsel.
Thank you.
Thank you, guys. All right, let me please do law versus surgery partners. Do we have a team? Not yet? Oh, we do. Okay, come on up, guys.
Morning, guys.
Morning.
How are you?
Good. This is law versus surgery partners.
Yes, sure.
And we have to incorporate? No? All right. This is the motion to continue, and I had a chance to read the motion. Is there any opposition, guys?
We've come to an agreement, Judge.
Oh, great. Excellent.
We didn't want to just submit an agreed order because we recognize that you special set us and you ordered special jurors.
I'm happy to do it whenever you guys want to. I'm happy to do it here for you guys.
So we're last 2 weeks in August, Judge. I'm sorry, July.
As long as it's okay with everybody.
Well, for my office, I'm not sure the length of time that the attorney will be trying this case, especially someone in the beginning of July.
Okay.
The trial docket that...
Another case?
It's in another case. The calendar that went around the office doesn't identify how long the trial will be, but that's the only thing that's in July.
Do you want to do, I mean, we can work around the schedule if we need to. I'll special set it, and if we need to start a day or 2 late, we can do that. Is that okay?
That's going to be an issue for us. We are in a special set trial the entire month of August.
Okay, so we have to finish before August then.
Right. So I think that if Judge, there's also a motion to bifurcate that's set for the end of the month.
Got it.
I think that if either way, however that goes, it's going to lead us down either a path to a shortened trial or to a mediation.
Sure, that makes
So at the end of the day, we're trying to give ourselves
Why don't
time
I
adequately.
please put you guys on the calendar? I'm going to grant the continuance. There's no problem at all, so that'll take the pressure off you guys.
Right.
And then what I will do then is I will reserve those 2 weeks in July. As we get closer, I can be flexible. That's not a problem, and I can work around the dates of whatever other obligations you guys have to.
Well, yeah, and just to be clear, what we were agreeing to, one of the reasons that we were willing to do this is there's been discussion that, I think you had us down, because they had told you this, 4 or 5 weeks.
That's what they told us.
And that
Right.
we think we can get this done in 2.5 to max 3.
Right.
So I think that helps even with your schedule and everyone's schedule.
That's perfect. So I'm going to grant the motion for continuance. I'm going to reserve those last 2 weeks in July for you guys. And if there's an issue, let me know, and I can be flexible.
We'll file our notices of conflict and everything like that, and we have 3 months now to, if
We
something
can work
comes up.
around it. I'll be happy to work around your schedules. I'll be happy to work around another judge's schedules. I'll do whatever I can to make it as easy as possible. Yes.
Great.
Okay.
And we have another proposed order, an agreed order that we'll submit to you.
Regarding the discovery issues.
Perfect. All right, thank you guys, and motion's granted. Have a great day, guys.
Thank you, Your Honor.
All right,
Can we be excused?
Yeah, of course.
Thank you.
Bank United Black, do we have a team ready now? Come on up, Bank United Black.
Sure.
I'm on that one,
Okay.
Judge.
Okay, I know you. All right, good morning. This is Bank United Black. This is plaintiff's motion to sub-party plaintiff and to change the case style. And I've read the motion. Is there any opposition?
You know, Your Honor, I almost never oppose a motion to substitute party plaintiff as long as I'm offered the opportunity to respond to any changes of issues or necessary alterations to my response to the complaint.
Okay.
In this case, however, it's a little different.
What's the basis for the objection?
The party that the plaintiff is attempting to substitute in, Wilmington Savings Fund Society, ceased to exist in 2018.
I can't determine that on a motion to sub.
But here's-
Summary judgment, maybe.
I have the documentation. I would ask the court to take judicial notice of FDIC and SEC
Can't do
documentation.
that on a motion to sub. I think you need to go ahead and file maybe a motion for motion to dismiss or motion to, I can't take judicial notice on a motion to sub.
I understand. My concern is, my problem is, we have a case here where it's kind of an upside down and backwards interpretation of 1.260.
Okay.
If the party dies, yes, bring in a new party or not, you can continue under the old name. But here they're bringing in a party that died before they tried to bring it in.
Okay.
And that's a real problem. I have another case where I beat Wilmington Savings. We have an attorney's fee award out of this circuit.
Great.
And they're refusing to pay, saying we don't exist. What are we supposed to do if we prevail again?
Okay. Well, let me do this. Let me grant the motion sub, and then I'm going to ask you to tee this up either on a summary judgment or appropriately, where I can properly take judicial notice and then potentially grant summary judgment in your client's favor then. And then you'll get attorney's fees in this case too then, if that
Well, if they'll pay it.
That's down the road. So, motion's granted.
Thank you, Your Honor.
Thank you. Just hand the order to the bail. All right, please let me go ahead and do LeBlanc versus CBR Medical Associates. Your Honor. All right, good morning. This is
Good morning,
LeBlanc
Your Honor.
versus CBR, and this is a plaintiff's motion to enforce settlement, impose interest, and award attorney's fees and costs. And if the counsel could please state their appearances for the record.
Good morning, Your Honor. Greg Hollander on behalf of the plaintiff.
Good morning, Your Honor. Neva Harney-Hill on behalf of the defendant.
All right, good morning. And I know the case had resolved. I went through the motion and everything. You may proceed when you're ready.
Thanks, Your Honor. So, the case settled on January 9th. And I've never done this in almost 30 years of practicing, brought this, and I regret that we have to. But the situation is this, okay? The Medicare language and that language of the release is almost secondary.
Okay.
What we have here is a settlement, okay? We agreed, you pay me money, in exchange we'll give you a release.
Got it.
End of story. Now, I didn't attach all the emails to our thing because it's exhaustive. It became an exercise of futility. I know defense has, but you can see in the initial email, no settlement was conditioned upon the receipt of an executed release or anything like that. Certainly, it goes without saying we're going to give them a release, but you pay us the money. There was no condition. Number one. Number two. Okay, all of this it's a simple premise case. Yeah, it's serious injury, but simple premise case. And they send over a 6-page release. Okay, the Medicare language, all that exhaustive, duplicative language, again, the settlement and the tender of payment of the settlement was not conditioned upon that.
Okay.
So, while we include the language in there, and I brought to Your Honor's attention the sections that were at issue, really to enforce the settlement, pay us the money, we give you a release. And they haven't done that. And, the payment of settlement statute kicks in here because they have made not only the defendant, but their insurer a party to the release. And obviously, it's been now almost 2 months since this case is settled. So we're asking the court to go ahead and enforce the settlement, order them to give us the check. Obviously, for the plaintiff, we'd like the court to order interest on it. And, attorney's fees for kind of having to go through this dog and pony show unnecessarily.
Yes, Your Honor. Absolutely, this settlement was conditioned on a release, an executed release.
But Mr. Holler saying he's going to give you a release.
I can't give him the check until I have an executed release. I have the check here, Your Honor. This is the check. My client is happy to read.
Can we just exchange it? Can we do everything in trust and exchange it at the same time, the check for the executed release?
Well, a couple of things, John. First of all, obviously, we asked her, in fact, when we settled it, I said, make the check payable to Honor Law Firm PA Trust account. we hold that in trust.
Is that what the
But-
check's payable to? Can we put it in his trust account?
My client would be having to register it with the court.
No.
My
You gotta
client-
pay money, that's too expensive. Let's just put it in the trust account.
It's here, I mean, but we need an executed release.
That's fine. Why don't we do this? Can I at least have the money put in Mr. Hollider's trust account, and I'll give him till, how much time would you need for the release?
Well, we have the
The
release.
problem-
The question is, and I think council's going to say, was agreeing upon the language. But in all fairness, that's the only reason, secondarily, I put in the release, that they're putting in language that imposes obligations on Ms. LeBlanc that are not only required, hang on a second,
Go ahead.
okay, that are not only required, okay, there's no basis legal or otherwise. Now, while she is a Medicare beneficiary, okay, we fully are willing to and agree to satisfy all validly existing liens, which include Medicare. We've already gone through that step.
You're gonna have to do it.
We're going to have to do that. But to have 6 pages
Okay.
of that is unnecessary, number one.
I would take care of that with the court on the liens. I mean, obviously, we can give notice on the Medicare liens, and I take care of that anyway. So can we just go ahead and do it in normal course, like the court would do? And you have to give notice, and we can take care of all the Medicare liens then?
Well, the language, she's a Medicare beneficiary. The carrier in this case, Your Honor, has very specific Medicare language. It's included in the release. It's quite frankly included in all the releases.
But that's okay, we'll just make it easy for you. I'll take the obligation. Why don't you put the money in Mr. Hollider's trust account? I'll have him do a notice of hearing, provide notice to all the Medicare issues, and whoever shows up, shows up. If there's any objection, they'll deal with it at that point in time. So that'll protect your client, your carrier, from any liability.
And what about the release? Does he sign the release with the Medicare language in it?
But you don't need to worry if they'll get notice in there, because they won't show up with any issues then. So,
And just to do it one step further, obviously, Your Honor, obviously, we have put Medicare on notice. We already have their conditioned payment. We have everything. We even have their reduction according to the program share. So we're ready to go. We're ready to pay Medicare.
We can put that in a court order then.
Yeah,
If you want
I mean-
to. That'll protect your client.
I'll put it in the order that
I'll do
we're
that
going to
all
pay
by, and I'll do it all by court order.
So what happens with the release? The Medicare language.
We'll just strike that language out, but we'll do it by court order. That'll actually give your client more protection then.
So the court order will say what? The court order?
Then all those liens are released at that point in time. So basically taking the language from the release and putting it, doing it after notice and hearing at UMC and putting it in a court order.
So that the Medicare language that's in the release will be in a court order?
Court order, yeah. So can you go ahead and put the money in Mr. Hollider's trust account, and then what you set a UMC hearing, give notice to everybody you need to, then, and then we'll put that, all that language in the Medicare release in a court order then, and that way that'll protect the insurance company.
Okay, and can I reference in the release that the Medicare, like a Medicare section in the release that it, and refer back to the court order?
Sure, absolutely. That's fine. That'll make it easier then. That'll protect both sides then.
Do you want a blank order now?
Yeah, or no, why don't you write it up and email us, probably easier.
Okay.
Okay?
All right, thank you.
All right, thank you guys. Have a great day. All right, let me please go ahead and do Flanagan versus Ginsburg. Counselor Ray? All right, good morning, guys. This is Flanagan versus Ginsburg, and this is our status conference. And good morning, guys. What is the status of the case?
The case is ready for trial, Your Honor, but we have an issue. Your e-docket is not until March 28th.
Yeah.
Dr. Ginsburg, she now goes by Dr. Hicks, resides and works in Alabama.
Oh, okay. I special set everything. When do you guys want to go?
April 22nd.
Is that okay with you?
Yes, Your Honor.
How many days for the trial?
I think 5 or 6, because we got a number of video depots that have been taken.
Not a problem then. Just let Michelle know. I don't think we have trial that week, and we'll be happy to set you number 1 that week.
Okay,
All right,
thank you, Your
guys.
Honor.
Have a great day. All right, Lakeview Lawn, we have a team running now. Lakeview Lawn?
Yes, he is right here. That worked out great.
Lakeview Lawn and McLaughlin. Let's do that.
Yes, Judge.
All right, good morning. This is Lakeview Lawn and McLaughlin, and this is motion for leave to amend and answer on affirmative defenses. Could count with corporal? No? All right, you may proceed when you're ready, counsel.
Yes, Your Honor, this is going to be, I just came on the case, there was a pro se answer that was filed, now I filed one that's maybe just a tad bit better.
It's just motion to amend. Any objection?
Judge, this case is already set for trial.
I know, but they can always amend. Motion to amend is granted.
Okay, thank you, Judge.
All right, thank you, guys. Motion is granted, Michelle. Okay. All right, let's go ahead and do U.S. Bank versus Collins. Thank you, Brett. All right, good morning. This is U.S. Bank Collins and Rick Corporate.
No, Your Honor. Amanda Lendergan on behalf of the defendant, Ronald Collins.
Yes, the plaintiff's motion to cancel and reset. Is there any opposition?
I think we agree on canceling, we just disagree on whether or not to reset. I want a reset date 90 days out, council doesn't want to reset.
We don't want to reset, Your Honor, just to save time, there is a 1.530 motion for rehearing pending. There's also a Regulation X lawsuit that's been filed against plaintiff. You have to keep coming back in to postpone it because of all these balls in the air.
What's the status of those other issues? Of the lawsuit shouldn't have anything to do with the sale.
If the sale goes forward, it takes away the party's ability to resolve the issue that's the subject of the Regulation X, but more importantly, because of the 1.530, Your Honor's aware you can't go forward on a sale with a 1.530.
I know, but I'm set it out. Why have you set a hearing on the motion?
We haven't been entitled to a hearing yet, Your Honor. It was sent to the court back on end of February. I have another copy here if Your Honor wants to copy it, just so you know it's still pending.
Sure, let me take a look at it.
We haven't heard anything yet for a hearing or...
Okay, motion to cancel and reset is granted. We'll set it for 120 days out. Motion for new trial set, you can set that for 8:45 any day you want.
Thank you, Your Honor.
Thank you, guys. Okay, we're going to set that for 8:45 and motion cancel and reset 120 days out. Thank you, guys.
Your Honor?
Yes.
On the Lakeview, we are, I didn't know it, but we are set for trial on March 13th, 2019.
Trial's off.
Great.
Yes,
Right.
they just amended.
Thank you, Your Honor.
Yep, thank you, guys. Okay, all right, let me go ahead and do Formato versus Geico Mazda. Anyone here on Formato versus Geico Mazda?
Welcome. This service is provided by freeconferencecall.com. Please enter your access code followed by the pound or hash sign. If you are the host, press star now. Otherwise, please wait and you will be joined into the conference. Please announce yourself.
Judge Sasser?
Please enter your PIN followed by the pound or hash. If you do not know your PIN, please enter pound or hash. Thank you.
Counsel?
And Ralph Formato. I was acting pro se, but I need to get counsel on this, and I ask that all legal proceedings be halted
Oh, we
until I can get funds.
That's fine, I'll give you 20 days. Mr. Formato, you have 20 days to get counsel.
Ma'am, I don't have the money to get counsel, ma'am.
I can't give you the money to get counsel. You have 20 days to get counsel. We can't stay. You filed a lawsuit as a plaintiff, sir.
I did what? I'm sorry?
You filed the lawsuit as a plaintiff. We can't stay a case, and if you don't have the money to get counsel, then you need to dismiss the case. Okay, 20 days to get counsel.
All right, from this moment forward.
From today, 20 days, all right, Mr. Formato?
I will definitely get the loan. I will get counsel.
All right.
I appreciate that. Thank you very much.
Have a great day. Thank you so much. Yes.
Are we not hearing our motion then?
Yeah, if he wants to get, no. I'm gonna, yeah, I gave him 20 days. We'll just reset your motion after 20 days.
Okay.
All right, thank you guys. Have a great day, everyone.
Thank you.
All right.
Do you guys have questions? Yes.
Just clarification.
Sure.
Your Honor, just a point of clarity. The order that we submit is going to have the Medicare language from my release in the order, correct, Your Honor?
I'll just do, well, it's just gonna, yeah, so your client doesn't have to sign off on it.
Well, I'm
So-
saying, she wants to basically cut and paste her language, and my point is, that was the secondary issue, that imposes obligations that I can't have my client agree to. I mean, she doesn't have to set up a Medicare set-aside, she doesn't have to do all these things that they put in there. I mean, we're gonna satisfy the Medicare lien,
Yeah,
period.
she doesn't
What
have to
else?
do Medicare set aside, that's not required.
And just to clarify, in all fairness to counsel, her argument, even if you look at the response, is her carrier requires this, her carrier requires this. Quite candidly, if I was dictated by every defense attorney and carrier's requirements, I wouldn't be in business. Just because they require it doesn't mean it's right.
Well, Your Honor, I've asked, I hear that, but I've asked counsel to then give me the language that he would agree to, and
How about this? How about
haven't
that?
done
Why don't you guys by Friday negotiate the language and put that in with that, if that works. Negotiate language.
Can I hold the check until the order is submitted?
No, put the money in the trust account. Okay.
Yeah.
All right, thank you guys. Have a great day, everyone. All right, anybody else from UMC other than Feinberg versus DeSisto? That's the last one? Mr. Grimsley, let me do yours. Is the other side here on your case?
Yes, Your Honor.
Oh, come on up.
I'm here now.
Okay. Good morning, everyone. Yeah. All right, we have a court order. If counsel and all parties could please state their appearances for the record. All right. Either side's fine. Go, you just need to state your name. Yeah, just state your, I just need your name so she can write it down, sir.
Kelly Schultz for the...
I have the materials.
Can't speak too loud.
You can speak in the microphone.
Can't speak too loud.
Yeah, that's fine.
Okay. Yeah, my name is George Princeton. I'm the plaintiff.
And Kelly Schultz for J. Michael Portman.
I read your motion, Mr. Grimsley. You may proceed.
The first thing I'd like to do is to give her a copy. Give a court a copy.
Sure, just hand us the bill. Thank you so much.
It's just a short outline of my talking points for this morning.
Okay.
And to be sure, I'm just going to read it so I don't have to lose time.
Okay, no, I read it.
You read it already?
I did.
I'm referring to my outline of talking points. I don't think you read that. I just filed it this morning.
Okay, no, that's fine.
Okay. For medical reasons, I have reduced ability to speak loud enough to be heard. For that reason, I have provided a short outline of my talking points intended for the hearing. I intend to read the following at the beginning of the hearing loud enough, hopefully, to be heard. I appreciate the defendant, Attorney Berman in particular, by accepting my suggestions in my letter to him on March 4th. That's why we're here today, because he agreed.
Got it.
And the copy is attached. I appreciate the court talking to your honor for hearing my motion to set aside the order of dismissal, my motion for rehearing, and motion to amend. I provided the court a copy of my memorandum of law and facts concerning the matter of due process. It provides clear direction as to what the court's ruling should be. I reserve the remainder of my time for final argument. Thank you, Your Honor.
Okay, that's fine. All right. What's your basis for rehearing?
This is not a rehearing. This is a motion for you to set aside your order of dismissal.
Okay, all right. Okay, all right. Anything else on the motion? Then I do the roll call. So anything else on? I mean, the case is dismissed. I know there was even an appeal filed. So what's the status of the appeal?
Hold it.
If I may clarify.
She asked me the question.
Sure.
Okay. That appeal had to do with the fact that I misunderstood your first order.
Okay.
Because it was not a final order.
Okay.
And after I realized it was not a final order, I voluntarily dismissed it.
Oh, okay. I understand.
It had nothing to do with this.
Okay, I understand. All right.
But Your Honor, thereafter, on December 18th, you dismissed this case with prejudice after seeing many amended complaints in this matter. And you know, while Mr. Grimsley did not appear at the hearing, you did see his, complaints as well as our motion to dismiss and considered those in your order dismissing with prejudice. So I don't think that any of the grounds, to the extent that they've been set out, should satisfy the requirement to set aside your order dismissing this case with prejudice. This case is closed.
Okay, all right. Anything else, Mr. Grimsley?
There certainly is. Number one, I immediately after I found out that you had entered this order, I filed my reasons for not appearing at the hearing.
Okay. I'll give you a chance. Let me give him a chance to be heard then, since he wasn't here. So just to be on the safe, since Mr. Grimsley's pro se. So what I will do then is, can we set this for hearing maybe the end of March then? And we'll just hear the substance of defendant's motion to dismiss with prejudice at that time.
That's fine.
Okay, all right. So I'll grant your request.
What date I need to know?
Last week of March, maybe? Is that okay?
The one issue I would have, Your Honor, is since the order dismissing the case, another complaint has been filed. Another amended version has been, because there was a motion for leave to amend. So I'm not exactly sure what complaint
Which complaint are we traveling on? Which complaint are we using, Mr. Grimsley?
We're going to use the last one, and I have a copy of it if you'd like to see it.
You just give it to counsel. What I'll do is I'll go ahead and give the substance of the motion to dismiss, but that way Mr. Grimsley gets a chance to be heard then. Yeah. So just coordinate a date the last week of March then.
Okay, I want to back up. You asked about the date being convenient.
Yeah.
It would not be, because I will probably be in the hospital. Okay,
well, we don't want to avoid that. So let maybe April.
So what we can do is go back to the original date that we had, which was the 10th.
April?
April.
That's fine. April 10th is fine.
Okay, that I can work around.
Okay, we'll work around you. We'll
Okay,
see you
now
guys
let's
later.
be sure, I want to be sure, I'm here, I'm coming back on the 10th to argue what I'm arguing today.
No, you granted what you argued today. I granted it. So we're gonna hear the substance of defendant's motion to dismiss.
So you granted my motion to set it aside?
Yes.
And to be clear, Your Honor, we'll have to file another motion to dismiss on the new complaint,
Yeah.
so.
I can address that when the time comes.
Absolutely.
So will I get a copy of it soon,
We'll
hopefully?
get the order today?
Okay.
Council, can you send an order then? So I'm gonna.
I can send an order, but we don't have, I mean, it doesn't do e-filing, so it all has to go by mail, so it might not be today.
It's okay.
Whenever you get a chance.
Sure.
No problem. This just gives them a chance to argue the substance of it.
Right.
All right, thank you.
Thank you.
Have a good day, everyone.
Thank you.
All right, let me go ahead and do, before we get to Farnborough versus DeSisto, I have a couple of hearings I can do in advance of that. I think I can do my 2 9:30s. Let me please go ahead and do, law versus, the motion for attorney's fees versus Kelly. Let's do that one. Come on up. All right, good morning, everyone. This is the 9:30 special set, and this is the motion for attorney's fees, the evidentiary motion. You ready?
Yes, I am.
All right, good morning. Do we have a court order? No, you don't. Okay, all right. This is the motion for attorney's fees, and I read the motion. You may proceed when you're ready.
Good morning, Your Honor. If it would please the court, I filed a motion for attorney's fees after I was advised that the case, after it left my office, had settled.
Yeah.
Nothing was different about the settlement. The settlement was for the exact same amount for which my law firm effectuated. It's a little strange because I have a contingency fee contract, which I filed with the court. I also filed an affidavit of attorney's fees based upon a quantum merit theory that I don't even believe should apply since the contingency fee had already hit at that point in time. The only thing I would add is that if it did apply, I would reduce my time by 0.7 because I went through my affidavit today and I can't bill for time and seeking fees.
Yeah, no, you can't get fees on fees. You're exactly right.
So I would like to amend that portion of the affidavit. But I have for Your Honor's consideration my affidavit of fees, the fee contract itself. I took a statement of the defendant driver and I was able to do that pre-suit. I have a notice of filing of an order over 4 years ago where my fees were validated at $5.75 an hour. I'm seeking $6.75 an hour, even if that's relevant. I have a notice of filing of the inventories of the estates. It was a tragic case. It was a minimal settlement. But fortunately, there were insurance proceeds, and the children collectively received about $1.2 million. And there was a GoFundMe where they also received a certain amount of money. I've met with these people countless times. My hours are a pittance into what they really were. The law firm of Cohen Milstein did reimburse me for my costs. I assumed that they would have litigated the case through trial, but the estate chose not to, which is certainly the prerogative of the estate. But I don't know what else I could have done possibly differently. And Teresa Leal, the grandmother, who's now deceased, did sign a contract, but I met with the aunt many times who flew in. Patricia, I feel terrible for the family. I met with the children. I've been doing this 26 years. And I'm not a huge law firm. I'm a one-man band down in Lake Worth for 26 years, and I do understand why they would want to have me waive my fees as that large law firm did, but I'm not in the position to do that, and contractually, they're obligated to pay me. Thank you.
Sure. So a contract is a technical legal document. And to have a claim from quantum root, you need to have privity with the client against whom you're asserting that claim. Mr. Custer had a contract with the grandmother.
You're right.
He did not have a contract with either estate, nor did he have either estate ratify the contract. Because he did not have either estate ratify the contract, and they did not sign a separate contract with Mr. Custer, he may have a claim against the grandmother, who's now deceased. But legally, technically, he does not have a claim against the estate. So his argument must fail.
And maybe it might be an unjust enrichment claim, potentially, legally.
Well, potentially, but that was impossible because at the time the firm took the case from me, it would have been impossible to have a contract in place with the estates that were formed thereafter.
Oh, this is tough. I mean, it's...
Well, that's actually technically incorrect. So the estate attorney was
Paul Klima,
who shares office space with Mr. Custer.
Okay.
And it was during Mr. Custer's representation that both Ms. De Silva, who was the personal representative, and the grandmother were appointed co-personal representatives of the estate. So there's nothing preventing Mr. Custer from redoing his contract or entering into contract with the estates, but for whatever reason, that did not occur. So again, his claim is legally, technically,
How can I help you? I want to try to help you, Mr.
Well, I don't think that it's technically defective whatsoever. I had a valid contract in place with the only person at the time.
But that's my own problem. I can only grant quantum error if it's the correct party. That's my problem.
It was the correct party at the time. At the time of the representation that I had, it was the correct party. Subsequent
where
to
did the
that.
funds go? That's the problem. How can we go ahead and collect? The funds went to a different party.
No, the funds went to my trust account, and I went ahead and sent the funds over to Defense Counsel. I had, at the time, effectuated a settlement of the complete policy limits.
Okay.
So under the contract that I had, back in March of 2016, I was entitled to the entire 33 1/3% of that.
Okay.
I chose to speak with the family to say, let's do some more
But
investigation.
which party? I just want to make sure we're talking about the right party with the right quantum merit. And the right client. That's my concern.
The grandmother and the aunt, although I might not have had her pen on there, she will. Yeah, but if you look at my timesheets, Your Honor, I met with her countless times, and if we were to get an affidavit from her or under oath, she is going to say that she in fact was being represented by me, because I represented the whole family.
Then maybe that might be a separate issue, though. Maybe it might be a different, but right now I don't have a legal contract, so I can't grant attorney's fees.
Well, I think under the parole evidence rule, that would suffice, because that, and I'm going back to contract law, which is not my forte, but absolutely did.
But that's fine, but then you would need to establish it. I would need to establish that there was a valid oral agreement, which I need to see potentially, and then there'd be an opposition to that. So here's what I'm gonna do. I'm gonna deny the motion for attorney's fees without prejudice. You can always amend and indicate there's a different basis of not a written contract, maybe an oral contract, use parole evidence, whatever you need to, and then they can oppose it. But Mr. Langine is right, I have to follow strict contract law as my hands are tied right now.
And if you were to follow that, Your Honor, I had a contract in place with the only valid party at the time the funds had met my...
And that's fine.
So why is my contingency fee contract as to that not valid? I believe that it is. I understand the argument, otherwise I would have settled it when they offered me money prior to coming in here today. My whole point is this: I had a valid contract in place with the only party that I possibly could have at the very time that the funds came into my trust account, thereby under Florida law and the Supreme Court guidelines in terms of my contract, I did in fact, they met my contingency, which is why I don't think it's a quantum merit argument. It's strictly a breach of contract at this point. And
but
therefore,
that's a different party. That's the problem.
No, it wasn't though. The only party that it could possibly have been at the time was the grandmother, who is now deceased.
But that's, well, I'm stuck with. If that's the only party you could be with. So maybe there should have been a substitution or an assignment potentially, legally. I'm just trying to think outside the box. It probably should have been assigned.
But the contract had already been met at that point. There was no need to do anything else because the contingency was already made.
Here's what I'm going to do. I'm going to deny the motion without prejudice. I think you need to file an amended motion as to indicate the basis for the attorney's fees from this particular party. And then Mr. Langino, you can do a written response at that point in time.
Thank you.
So, Your Honor, the quantum merit for the hours up to the point where I had effectuated a settlement on behalf of this individual, wouldn't that certainly, that 7.2 hours at least be something today that the
What
court
about
would...
the original part? Any objection to that, Mr. Langino, just the 7 hours?
Simply because, again, civil litigation and contracts are technical. If I represent a brother and he's not appointed representative of the estate, at the time I represent the brother, he's not the party to the action, right? And here, he had a contract with the person who's not a party to the action, who's not the proper party. So again, he may have a claim for unjust enrichment or quantum merit against the estate.
It might just be an unjust enrichment case. And you're welcome to do that. Maybe that's the way to get them to the table and get them to settle potentially.
But unfortunately, because the trustee consented of this case, my firm waived their fees. Right? He doesn't have the legal entitlement to fees, and the fee should go to the children.
Okay, all right, so...
Well, certainly we'll handle that under a different legal theory then.
Yeah, I think it might be different legal theory then.
That's fine.
All right, thank you guys.
Have a good morning. Thank you.
Thank you guys so much. All right, anybody else other than, let me do the other 945. Valley National Bank versus Evans, are both sides here? on that one, Valley National Bank, Evans, and then we'll do Feinberg versus DeSisto. Both sides here, or we're just waiting?
No, both sides are not here.
Oh, okay, that's fine. Let me do Feinberg versus DeSisto, and then we'll do Florida Bar.
One moment, Your Honor.
All right, come on up, guys. All righty, thanks for your patience. We'll make sure you get out of here in time. All right, so I went through everything. I went through all the illegal objections. Let me hear from defense counsel. What's your response on the issues, on the objections?
Well, I've broken it down.
And we can do it by categories, so it'll make it easier, I think.
And we discussed that.
We discussed that.
Oh, good, okay.
Essentially, the county, who was a party to the suit, hired an expert named John Lloyd.
I saw that.
They've sort of adopted him as their expert.
Yeah.
And as a matter of fact, when you look at the deposition, when you read the deposition, you can tell the plaintiff's counsel is using him as their expert. They're qualified.
Sure, that's fine.
So he creates this animation showing how he alleges how the accident occurred and where the accident occurred.
Okay.
We asked him specifically, how did you determine where the accident occurred?
Okay.
And on page 57 and 58 of his deposition, we asked him specifically, 57, line 6, how did you determine the location of where this accident actually took place? Answer, based on the guidance of Mr. Johnson, an employee who didn't witness the accident, and Ms. Lindsay, the attorney who hired him. And then we go on and we ask him, he goes on to say, because there was some disagreement between the plaintiff, Ms. Frydenberg, and the defendant, Mr. DeSisto, as to the exact location. So he's acknowledging that he based his diagrams and his animations on what the attorney who hired him told him, and what Kevin Johnson, the employee of the golf course, told him. And he specifically says, to your knowledge, did Kevin Johnson witness the accident? No. Yet you relied on Kevin Johnson to show you where the accident took place? Yes. Page 58, line 12, we ask him again. So you determined the location of the accident, the location of this golf cart path, based on information provided to you by Kevin Johnson and Attorney Lindsay? And he says, yeah. And Matt Hood, another employee, and Matt Hood provided some information to likely provided the information to Mr. Johnson, and it's in my understanding that Mr. DeSisto had a meeting with Mr. Hood. So everything he's saying as far as his animation goes, as to where this location goes, is based on what the attorney told him or what Kevin Johnson, the employee.
Does that go to weight?
And in Your Honor, it's not true. If you go to the deposition of page 61 at the bottom, it says, where did you determine, based upon talking with Johnson and anyone else, as to where the exact location occurred? The exact location was difficult to determine, so we determined, I think it was approximately 16 parking spaces from the start of the path. Mr. DeSisto, in his deposition testimony, suggested that she entered the path through the walkway that was 16 parking spaces back.
Should we let the jurors decide this issue?
But how do you allow the jurors to decide whether or not an expert relied on hearsay?
An expert cannot rely on hearsay.
Not certain types of hearsay that normally experts rely upon, they can rely upon. But experts do not routinely rely upon what the attorneys who hired them to formulate their opinions. And there's no predicate for
But
this.
Mr. Reddick just read what the basis is. So that,
but he never said that was his basis. His basis was the attorney.
All right, defense request is denied then. So I'm going to overrule those objections. Oh, those objections are ruled.
Okay. Next category, sir.
Biomechanical opinions of Mr. Lloyd, who's not a medical doctor. If you look at his testimony.
Yeah, no, that one I read. Let me ask you, how's he going to testify to that? I've never had him in the courtroom.
Well, he's going to be on video, so it's already done. So the issue here is, and there's plenty of case law, and I cited it to you. He can say from a biomechanical point of view, her injury was consistent with being hit by a golf cart.
But he's not a biomechanical. Is he a medical doctor?
No, he's a biomechanical engineer, but there's plenty of case law that says he can't say whether her injury is permanent. He can't give medical testimony. He can say it's consistent with being hit with the golf cart. And frankly, there's no doubt she was hit with the golf cart.
You're being led right into error. Because what she's saying is not true. And biomechanical expert who is not a medical doctor
can talk about how the body moves, but can't say it's consistent. I agree.
He can talk in general terms.
It's sustained. Defense objection sustained.
Well, Your Honor, I do have cases that suggest to the contrary, so we'll preserve it.
Yeah, let me go ahead, and I'll be happy to see it if you have those cases. But yeah, because
actually, it's a case that he cited. Nadine. Let me see if I can find it.
Okay.
I think it is.
Why don't we do that at the time of trial, guys?
Yeah, we'll do it at that. Well, we're trying to get the video.
Oh, wait, okay.
But that's all right. So we'll move on. But there is case law that says they can't say consistent with, but they can't say permanent injury.
Okay.
They say her injuries to her left knee were consistent with being stricken by a golf cart.
I agree with defense. Objection sustained.
Okay.
Just, Your Honor, do you have the deposition in front of you?
I do.
I would direct your attention to page 35, line 24 through page 36, line 17.
Okay. All right, so let's proceed on that one.
I'm turning to the page 2, Your Honor. The question is, it is your understanding that this golf cart path where this crash occurred, that pedestrians, it was expected that pedestrians would walk across this to get to the driving range, correct?
Yes.
Is that a proper question for an expert as to expectations? It's vague and it doesn't specify what people have these expectations.
Response?
Your Honor, everybody had the expectation. It was a shared pathway. There's absolutely no testimony to the contrary. This pathway was used, you had to go across it to get to the golf
Is that
course.
stipulated by defense or not?
That this pathway was
They had to cross
used?
it.
Their expert says it was used.
Oh, I understand. This pathway could be used to cross from the parking lot to the driving range. There's no doubt about that, but it's just the question, as it's phrased, it was expected.
I agree. Sustain the objection.
Just to move ahead, and I might be, if you turn your attention to page 44.
Okay, got it.
I'm trying to hurry you on that.
That's okay. We want to make sure you get to crosswinds on there.
Page 44, line 20, where plaintiff's counsel is asking him, when we have a situation like this, when we have a pedestrian in the golf cart path, describe for the jury the duties of the driver of a golf cart path as he's approaching. So I object to any questions to an expert about what duties exist. That's a question of law. There is the case which I provided, Fuentes versus Sandal.
Yeah, I don't need to. I'm familiar with that case. Let me hear a response.
Your Honor, this is a case in which we're not asking, he didn't tell the jury how to decide the case. And that's what the case law says. He can talk about areas of law, but he can't say she violated the right of way or he violated the right of way. He can say the right of way says the pedestrian always has the right of way.
Okay.
But he can't say, in this case, she violated the right of way or he violated the right of way. And that remains for the jury.
Okay.
So that because the legal duties are contained in the statutes, the jury will be instructed with the statutes. And it's up for them to decide.
But the problem is the question is phrased. Defense objection sustained.
Page 41. And I know we're jumping around a little bit.
That's okay. I'm with you.
But I think once you have these, we'll be able to go through them.
Excellent.
Page 41, lines 15 through 20.
Okay. Well, let's hear that one then.
Just asking the expert whether he read Mr. DeSisto, the defendant's testimony, and whether he recalls it, and whether or not he agrees with that testimony. The question is, do you agree with that testimony?
That's proper. All right. Objections overruled.
Page 38. Lines 13 through 23.
Okay.
Does the testimony of both the plaintiff and defendant support the notion that this crash did not happen because Karen Friedenberg suddenly stepped out from the pathway into the line where Mr. DeSisto was driving? Correct. So I object to the phrasing of the question. It's an improper opinion. It's an ultimate issue, and it's leading from their expert.
Overruled.
And then, Your Honor, we really just get to the one last issue, which is this right-of-way testimony by their expert, who's a biomechanical expert.
Okay.
He testifies that he didn't rely on any statutes or base his opinions on any statute, yet he comes up with these opinions on right-of-way that A, the plaintiff always has the right-of-way, and B, how do you base that? Well, because of the propensity for injury. Since plaintiffs have a greater chance of getting an injury, the plaintiffs have the right-of-way.
All right,
You just can't have that type of testimony.
Your Honor, I think the testimony is consistent with the statute at subparagraph 15, and it says that
We don't need expert witness testimony on that, right?
probably don't need expert witness testimony on that, but on the other hand, his guy talks about the statute too. If it's good for me, it's good for him. His guy
Sides
can't.
are going to talk about statute. That's for you guys to argue to the jury.
Well,
The statutory issues it's a matter of law for us to decide with the jury. So neither side should do it, neither expert should do it, and you guys can argue that in your closing arguments. And I'll take judicial notice of the statute. That's not an issue.
Your Honor, this is not set for today. This is another issue. You've continued us.
Mm-hmm.
We were set a couple of weeks ago. You continued us to March 25th.
Yeah.
On the day you continued us, I get a brand new report from their expert, Dr. Who we've already deposed. I filed a motion to strike him. I'm just letting
Is it
them.
updated?
It's updated based on the fact that she has.
Do you need to redepose
We've offered, Your Honor.
You got a couple weeks. So.
I do, but my problem is my experts, and when I was trying to, you probably saw some of those emails back and forth. I had difficulty with the week going with the 25th.
Do you want to do the week after?
No, Your Honor, we already have our guys lined up.
I know, but my problem is now we got an affidavit from Licklau, and I want to use the Licklau Act, but I don't want to prejudice defense, so I got to be fair to both sides. Why don't I move you guys one more week later? Would that be helpful?
No.
Well, no, I know, I understand. Mr. Rannick, I'm trying to be fair to both sides. If you amended Licklau, it's only fair for defense to take an updated Licklau deposition. And then, I understand, but I'm trying to work around everybody's schedule. So.
It's what I'm trying to do.
Can you be ready by the 25th? If not, I'll give you another week.
What I'm trying to do is to get his report to my expert. The reason why I've had trouble with the 25th is my expert aren't available. I'm having trouble getting this report to them to give opinions on this.
Your Honor,
That's
it's an
where I'm
email.
at.
I said it by email.
Okay.
But
Trouble getting it to them, that's nonsense.
It's not nonsense. They're out of town. One of my experts, his son was undergoing surgery.
Okay.
I mean, I'm doing everything I can, but that's where we're at right now.
Okay, all right. Why don't you guys do this? Check with your calendars. I can do it on the week of the 25th or the week after. I will do it for you guys, whatever you guys need. That's not a problem then. And then let me know what week works best. Okay, but you can take the updated deposition after the fine. I'm not going to strike Licklau.
No, but I mean, we'll make him available. It's
Yeah,
not an
make
issue.
Licklau available for the updated deposition.
And they've offered that. I understand that. You know, just going back to the Mr. Lloyd, we've already touched upon this. He was originally hired by the county.
Okay.
So he was paid for by the county, and he was formulating opinions.
I know, I
for the
remember
county.
when the county was in the lawsuit.
The county is no longer in the lawsuit.
I know.
And you know, but I'm still entitled to at least mention to the jury that he was originally hired by the county, and he was biased to show that I'm entitled to show that a witness is biased, was being paid by certain people. And I know normally you don't mention about entities that have now been dismissed and have settled, but in this case it's a weird twist.
You need to
because
give me
they're now
any case
using
law on
this.
that. I'm going to sustain plaintiff's objection. Give me any case law on it, and I'll hear it at the time of the trial. All right, thank you guys. All right, have a good day. Let me go ahead and do the last foreclosure hearing, please. This is Valley National versus Evans. Come on up. All right, good morning. This is Valley National versus Evans. This is the motion for summary judgment for the court order? Yep, okay. All right, you may proceed with the motion. You're ready, counsel.
Thank you, Your Honor. Your Honor, my name is Andrew Fulton. This is actually a commercial loan case.
Yeah, I know, I saw that.
Yeah, it's involves a individual borrower and a law firm.
Yeah.
There's a promissory note, guarantee, and there was a security agreement. But we're really talking about it in the grand scheme of things. What we're really talking about is the personam obligation.
Yeah.
We filed an affidavit of proof of claim setting forth the fact of the loan documents, the admissibility of the loan documents. And
Yeah, let me hear from defense counsel. What's the objection, if any, to the summary judgment?
We filed an answer with affirmative defenses stating that there was a loan modification that was accepted and then carried out through a course of conduct. My client could have refinanced, could have got lower interest rates.
Did they make payments on the loan amount?
They made payments the entire time. They were never in default for payment. The bank probably got nervous for reasons and just called it due, not for non-payment, claiming it was a demand note. And so they filed two motions to strike affirmatives, which we denied. They filed a motion for prejudgment, which is denied. And in the whole course of those
Sounds like we need to go to trial.
I filed affidavits that they haven't even addressed.
Yeah, I think we need to go to trial.
If I may address the issue just very briefly. I understand Your Honor's.
Yeah,
I understand
it's
why.
affidavits, yeah, and
But
the loan non-payments.
Here's the thing, Your Honor. First of all, if Your Honor looks at the promissory note, you'll see that The promissory note has very explicit language. It says that if the client does not pursue it to fall under one set of circumstances, it's not a waiver, it's all. And the other thing is, in the guarantee, there is specific language that says that any amendments must be in writing.
Okay.
And
I know,
what
it's a
they're-
genuine issue material back then, I don't think I have a choice.
Okay.
Yeah, so I'm going to deny MSJ, how much, you want, just go ahead and notice of trial.
I'll.
Shouldn't be that long a trial.
It's a bench trial. It's a bench trial. Okay.
Just set up a bench trial, we'll set it in 30 days.
Okay, thank you, Your
If
Honor.
you guys just email Michelle, just give us notice of trial, it's not, say non-jury, closure case, we'll set it in 30 days.
Thank you, Your Honor.
Thank you, guys.
So when did trial?
No big deal.
Thank you.
Come on up. All right, come on up, please, on the floor bar, and get everybody set up.
Your Honor, should I just submit an order?
Yeah, just deny it.
Thank you.
And any case shall be set for trial within 30 days.
Thank you.